welcome to the MedSpa Coach podcast. I'm Kelly Smith, founder and CEO of Projected Growth Consulting. And today I have the privilege of speaking with Sara Shikhman, owner and founder of Lengea Law, as well as a background as an author and a co-owner of a chain of MedSpas. She also was in the software industry and created Aesthetic Record, which I'm sure a lot of our listeners are very familiar with, as well as your law firm. And I don't know how many of them know about your MedSpa Confidential book, but I really enjoyed taking a look through that and learning your background. So you've been in the industry, you said, since 2014. And I'm going to let you share a little bit about your journey because it's just it's a unique blend of having legal software, being an owner, as well as, writing the book and Aesthetic Record. So I'm really excited to dive into the top 5 legal mistakes that you see, and don't fret. She's going to share how to address those and fix those, because I think a lot of us are afraid of the monster in the closet. Sometimes it's scary to go look for a legal advice. We're afraid it's going to cost too much, things like that. At least that's what I hear. And I love also the membership subscription type of opportunity that you give for people to get started, especially if they're new, because there's so much involved in starting up a med spa. I started in the industry by opening up my own med spa in Eastern Washington in '99 with my sister. We did like $1 million in the first year, and we were seeing so many clients, and I absolutely loved it. But 20 employees, started having a family. It just was like this juggling act. And so I thought, gosh, I need to sell this and decide if I want to do consulting, what I want to do. So I went and got a book then, about 2004. I grabbed a book, How Do You Sell a Business? And it said, go to your main competitors and talk to them. And I thought, well, that's kind of scary, but I went to 2 of my competitors, and one of them was interested right away. And it turned out to be so much easier than I thought. Now, I wish I would have had more legal instruction, because it was a lot more difficult to do the transition than I expected. And so after I got out of that for a while and I had kids, I ended up getting back into helping actually a friend who was an injector that wanted help with a small practice out in Coeur d'Alene, Idaho. And 2 doctors wanted out of rounds, and they were surgeons. And so we had to figure out how to take them to a profitable level so they could actually, make a living with the med spa idea. And at the time, they were a laser and vein clinic with 2 male doctors. So we ended up getting into minimally invasive and really tapping into finance, marketing, and some of the stuff you talk about, in your book. But I'm excited to talk about, since my top 10 profit killers, and how to avoid them. Today, we're on the top 5 legal mistakes, how to fix them or how to avoid them, because you work with a lot of startups as well. So if you wouldn't mind just kind of sharing a little bit about your journey, because it's been super interesting talking to you and learning more about it.
Thank you so much. And I'm so happy to be here, Kelly. Really excited to be part of this. And I think we share some of the common background and our approaches to a lot of things. So it's really cool to be on a podcast with someone like you. So I guess I've been an entrepreneur for a long time. I've always wanted to start my own business. Even in college, I already had my own writing business. And then in law school, I was selling furniture basically on the side, helping my friend's furniture company as I was trying to finish law school. And then I started at a big firm, and I practiced law at a big firm. And then I worked at a big investment bank. And then a couple of my friends were starting an e-commerce furniture company, and they were like, we need a CEO. And you don't know anything about furniture, Sara, but you're good at helping people figure things out. So you're going to be our CEO. And I was like, okay, let me try that. And so I did that. And then I met my ex-husband, Justin, and he was starting an aesthetics clinic, Jubilee in Columbus, Ohio. And it was a great opportunity to run a different kind of business. And so we ended up starting that business together, and then starting the software company, Aesthetic Record, and really got to know running the aesthetics practice from the ground up, from really 1 room to 12 locations, which was really a fantastic opportunity for growth, but also opportunity for learning and opportunity to make some mistakes.
Yeah, 12 sounds stressful. It's kind of like when you have that third child and you don't have, you're outnumbered. 12 is a lot.
Yeah, and 12 it was split among, I think it was 5 states. Yeah, I don't recommend that strategy anymore. I would say that was a crazy, that was a couple of years on the plane. But then in 2019, I started the process of getting divorced. I had to start everything over. And I said, I really love helping people. And the side of that I like helping people from the most is the legal side, because it's something that I know, it's something that I've lived through and experienced. And so let me start this law firm. And I started Lengea in 2019, literally with nothing, like with one client. And now we have 10 attorneys on the team, over 1,200 clients. We've helped so many people start, grow, sell their practice. So it's been really an amazing journey, and I get to do something that I love every day. So I'm really thankful for that.
Well, I was really excited when I learned about your specializing in the industry, because I wasn't really aware of, law firms that were doing that. And then the more I got to know you and realized that you had, been an owner and had multiple locations, so you knew what that felt like. Because so many people have stars in their eyes. I get a lot of startups like you do, and so many of them also think that they're going to open up multiple locations and not even be on site. And even though they might be a physician, they don't want to be a provider. And it's just the reality of running one of these businesses is, the customer service experience is so important, and people are spending a lot of money. They expect a certain experience and a level of experience, and it's not kind of one of those hands-off businesses. And definitely, to franchise or to create multiple locations, you have to have that left brain scaling mentality of systems and processes. And obviously you have that, being legal as well as software with writing aesthetic records. You obviously saw there was a need to organize it, because it can be a little bit like cowboys, running around out there. And there's all kinds of, sometimes I even still today run into practices that are trying to run their practice on paper files and Google Sheets and Excel and things like that. And it makes it really hard to jump in and help them. So fun fact, I thought I wanted to be an attorney when I was in college also. And I interned downtown Seattle because I was going to University of Washington. And I was like, well, I don't really think I want to do this. As much as I liked all this, Boston Legal and everything on TV, it looked really glamorous, a lot like how glamorous it looks to own a med spa. And, you walk in and it's like, oh, so pretty in here. This is wonderful. And it's like, yeah, you don't know we're running around, trying to take care of things and not having time for lunch or restrooms or anything. It can be a pretty rigorous schedule. So I do talk to people about the reality of, you got to get, if you're really wanting to do this, it's the happy side of medicine. I love making people feel better about themselves, but it's a business, and the first couple of years are there's a lot to do and a lot to organize. So I'm excited for you to kind of share with us, like we were talking about, those top 5 legal areas that you see come up time and time again, and your thoughts on how they can fix or maybe avoid it if they're in that startup mode.
Yeah,
So what's
definitely.
that big first one?
Yeah, so the big first one is not having the right legal structure from the start. So what happens is, in many states, you can just open an LLC very simply on, like, online, on LegalZoom, using like your accountant, whatever. But in many states, that's not the right structure for this type of business, because there's this prohibition called the Prohibition on the Corporate Practice of Medicine in over 30 states. What that means is, technically, someone who's not a doctor or full practice authority NP can't directly own a medical practice. So there's no licensure required to open this kind of business in many states. So you can physically go and open an LLC and start running your practice. No one's going to say, oh, no, you made a mistake, until you consult with a lawyer. So what's happening is, sometimes people are able to open it and they say, well, I was able to open it, so I'm good, right? Unfortunately, not. This in many states, the structure that's needed is a little more complex. It's not crazy. It's not like you have to stop all work and say, oh my God, like I made a huge mistake, my life is over. But it's more of a like a very precise legal structure that needs to be in place before you start. And the reason it's important is because whenever there's any issue, whether it's an employee issue or an issue with a board or a customer issue, everyone starts looking under the hood and trying to find something wrong with your practice. And so then they call an investigation on you from a board. And then the first thing they ask is, show us your organizing documents and your relationships with your medical director and how is your business structure? Who owns it? And that's when you're like, oh, here's my LLC. And they're like, oh, that's not going to work. That's not correct. We need to suspend your operation until you get everything fixed. So it's it's a really avoidable situation and a fixable one. So that's the biggest legal mistake that we see.
And I see that a lot as well, because when people come to me and tell me their vision of what they want to do, what they want to open, and I'll ask them, what state are you in? Have you looked into, if you're not if you're not an MD, if you're a registered nurse or a nurse practitioner, depending on what they are, or maybe they're just an esthetician, and in some states they can do that. But
Mhm.
that's my very first question is, have you really looked at, number one, can you legally own, and what structure do you need? Do you have an attorney and do you have a CPA? And if not, let me send you a couple recommendations so that we get that started right. Because then that leads right into that other part of who's allowed to operate what equipment. So if I'm trying to help them figure out what services to offer, I need to know what state they're in and what requirements. We all know that California, New York, you have to be a registered nurse even to do laser hair removal. There's some things that come up. Same thing with the ownership. So if someone realizes, or if they check into it and they realize that they really do have the wrong structure or they're not following the rules, can they contact you? And then do you basically, how do you fix that?
Yeah, so what we do is we have a compliance audit that we do. So we would ask a couple of questions like, okay, show us your paperwork, whatever you have. If you don't have anything, it's okay. Show us what services you're doing and who's doing them and what processes you have in place. Like, do you have someone doing good faith exams? Do you have a good contract with your medical director? Do you have an MSO in states where you need one? All that kind of stuff. And so, yeah, we could always come in and once somebody's set up and once we do a compliance assessment, and then we would give somebody like a plan of what we should do to restructure things a little bit. And it's a gradual process. It's not like we have to shut down your practice and have you start over. We kind of go step by step from what's the biggest legal liability to the smallest legal liability. And also there's a lot of tricks and tips that a lot of people don't know. So for example, in New York, the practice of laser hair removal today is considered non-medical. So technically anyone can do laser hair removal. Like it could be
Is that new? Is that a new change or?
and no, it's always been that way, but it's a very little known fact. So laser hair removal in particular in New York can be done by anyone
Okay.
once they have training. So but once you call it a laser facial or laser resurfacing or any other laser besides laser hair removal, then it has to be an RN or more. So it's kind of like even if somebody's non-compliant, there are all these little known rules in different states that can help you that lawyers know, but you have to talk to a lawyer. Otherwise, you just may not know the answer.
Well, and I didn't even know that because I work with a lot of practices, and they just lump all the laser together. So I didn't realize that about New York. And a lot
Yeah.
of people might not know what MSO is. Can you explain that?
Oh, yeah, definitely. So in the states that have this prohibition on the corporate practice of medicine, which is a little bit over 30 states right now, um, a non-physician can't technically own a medical practice, but you see a lot of people owning this kind of practice all the time. So how do they do it? They do this using a structure called an MSO, a management services organization, where you as the registered nurse or business person or esthetician or whatever, licensed or unlicensed, would own a management company. Your management company, otherwise known as an MSO, would control a lot of the assets and business decisions of the practice. And so that would be one legal entity that we would set up for you. And then your legal entity would then contract with a medical director in a contract called an MSA, a management services agreement. And so in those states, that's the way to be compliant and still have a lot of control in this space. And then in this whole MSO structure, your MSO, which is a special kind of LLC, becomes the valuable thing. So once it comes time to sell the practice or get investors or whatever, the MSO would be the thing that you own and that you're selling to private equity or somebody else.
So as a non-physician, you can have majority ownership in the MSO versus if it's a practice, you couldn't just open a medical spa and have majority ownership. Can you have minority ownership can you be like 49% without doing an MSO if you're not the right, licensure to own?
Great question. So in an MSO, you could own 100% of the MSO. So you don't even have to be like, you don't have to split shares or make your medical director part of the MSO. So you would own 100% of the MSO. The legal medical entity, in some states, you could own a minority percentage if you're not a physician, but in some states you can't. So for example, in New York, a physician and a non-physician cannot partner in a practice entity. So you couldn't own a minority interest. In California, you could. So it's kind of state by state specific, but a cleaner structure, I think, is where the physician owns 100% of their company and you own 100% of the MSO. That way, when you're selling the business, or if, let's say, things don't work out with the physician, you can just cleanly separate. You don't have to buy anybody else out. It's two separate companies. For most people, that would be the structure I would recommend in the states that require it.
Okay. Well, I think that leads so nicely into, we talked about the five, and one of them that you and I talked about, which I hear about a lot, is that good faith or medical director, the good faith exam, the sign off by someone appropriate before people are treated. Do you want to kind of segue into what that means and options of how to deal with that if perhaps you're not a doctor that's doing the good faith exams?
Definitely. And that's really the number one area of like investigations, non-compliance that we see. So what happens is a investigator comes in pretending to be a patient. They say, oh, I want to get, Botox right now. Let's say are a registered nurse, they come in, you do their intake, you say, okay, yeah, for you, I would recommend 50 units, and you start doing their treatment. And right before you're about to start, they're like, oh, my name is Marcy from the, medical board of X state. You're under investigation because, someone reported you for not following procedures and not having the right structure in place. So
making me nervous hearing that, because I'm sure that as people listen to this, they're going to be like, that can happen. Oh no. Because unfortunately, a lot of people are not following the rules regarding that good faith exam. So this is great. Keep going.
Yeah. So
it's making me nervous.
that can happen. That does happen. We get probably 5 to 10 phone calls a week of that happening across different states. So it's happening more and more. And so in every state, no exceptions, if you're going to do a medical procedure on someone, they need to have a good faith exam done by someone who can be a prescriber in that state, which typically is an NP, a PA, or an MD. And that good faith exam has to be done before they get any treatment. Unfortunately, there are no exceptions to this. So Marcy comes in for Botox and she wants it there and then. You either have to have an NP or PA on site to do her quick good faith exam, or you have these outsourced companies that you and I spoke about the other day that you can call, and for about $30, they do a good faith exam instantly. They're available on demand 24 hours a day or close to that. Two of those companies are called Qualify and Spa Connect. I'm sure there are others. Those are just the two that we work with all the time. And essentially what happens is new patient comes in, let's say you don't have an NP or PA on site, you call these companies, they do the good faith exam for you, and then you as, let's say, an RN can do the treatment. in the states that allow an RN to do whatever you're going to do, which is a lot of states.
Is that a virtual Zoom kind of thing, or is that just by telephone? They're just asking health history. How does that
I think
go?
they do it by video. So I don't know if they use Zoom or another
Or
platform,
probably
but
something HIPAA compliant, but it's a video kind of,
video. Yeah.
right. Which during COVID and all that, it's more and more telemedicine started happening, and virtual medicine started happening. So if you use a solution like that, you have to have an official medical director, or can you just contract with a company like that? I mean, because you still need to order product, so you've got to have a medical director to order product.
Yeah, so it's kind of two separate things, and that's a really good question. So what do you need for good faith exams? You need to have an NP or PA or MD doing them, sometimes remotely, like with these services. But separately, what do you need for your legal structure for the business to be compliant? And that's a medical director or an MSO structure, depending on the
Mhm.
state. And then to open your accounts with a lot of these vendors, they will typically ask for a medical director's signature, at least in the beginning, to open an account where they'll ship drugs to you.
Right. So whether you're wanting to open your Allergan account, or even if you're trying to maybe, well, purchasing laser, sometimes you can get away with the purchase, but then it's the disposables and ordering those kinds of things. Every once in a while, people squeak through um, the purchase and the setup, and then they can't order the disposables.
Yeah. Yep.
Okay. Okay. So those two, so that's great to know, because the industry's growing so rapidly. There's lots of startups, lots of expansions, franchising going on. So I think those things are so important. And I was really excited to hear about that option of being able to do an on-call one, because that's usually one of the things we talk about is, should we just have the medical director be in one day a week, to do sign-offs in order to make it efficient? But then you're challenged with that person, like your example. Someone comes in, they do their consultation, and we want to treat them then, and they want to be treated then. So what do you do if you're trying to play by the rules and really make sure to stay in compliance? So that's really great advice.
Thank you. Yeah, I mean, I understand we never want to turn away a client, right, who's ready and willing and able to get the treatment. But at the same time, we have to follow the legal steps too. But there are these ways to do it in an efficient way. I mean, paying $30, it's not nothing, but it's very, very much less than having a full-time person on staff.
Of course. I mean, because even if it's a 15-minute, good faith exam, telemedicine, you're still going to be $25, $30 an hour for a doctor to be in there, because you're $100, $200 an hour for a doctor to be in there. So it still seems like a nice alternative. So the biggest one, the first one, is the legal structure, understanding what's required and what your options are. The next one is, what do you do regarding good faith exams to make sure you're in compliance there? And what does that lead us to for like a third area?
Yeah, so for everyone who's insufficiently scared, there's the third area is policies and procedures and having things in writing. So the biggest way that we see that play out is sometimes people do things outside of their scope, or sometimes people do things that you don't expect them to do. But there's a miscommunication, or there's a lack of communication about what's the expectation versus what the person did. So then it's hard to know, like, whose fault was that. So one example of that, let's say a customer comes in and they say, well, at every practice I've been to before, they've always treated me with filler here in the nose to make my nose a little straighter. And your injector, based on their experience, decides that they're comfortable doing that, and they do that treatment, and the person gets a vascular occlusion. And you say to your injector, oh my gosh, like you weren't supposed to be doing nose filler here. That's not a treatment that we do.
I love the real world examples that she's giving us, because they come up all the time. And it would not be uncommon at all for your injector to say, oh, sure, I know how to do nose filler, or they think they know how to. And so that's not an unreasonable example of, you'd written the job description for your nurse to do injectables, right? And they had been signed off on different injectables, and maybe they might know the technique, but it's not something on your menu, like you say, and then it goes terribly wrong. So go on.
Yeah. So in this example where somebody does nose filler on someone and it wasn't your expectation that they would do that, a good way to protect yourself from those kind of situations, and something that's legally required in many states, is to have policies and procedures and protocols for people to follow. So this would be a manual that your whole team signs off on, and your medical director, where they agree what are the procedures that everyone is authorized to do and how are we going to do them. Like, it doesn't have to say we only do, 20 units of Botox like this, but it has to say something like the most Botox we would inject is X, and the areas we could possibly treat with it are Y. So it would be a pretty long book that talks about every procedure that you do, who's authorized to do it, what's allowed, what's not allowed. And so that thing on the medical side will help you protect yourself if there's ever an issue. Because if your team member does something outside of that book and they agreed to that, they're not going to do that, the liability shifts a lot from you to them, because here they're acting outside of what they were supposed to do.
And that's as long as is it just providing that document or having that document signed and dated that they received it and they're acknowledging it?
Yes, it's definitely having the document signed and dated. So it wouldn't, just providing it would be better than not providing it, but having a signature and a date would be much better. And then having it reviewed every 6 months or 12 months and re-signed would be even better, so that no one can make the argument that this was a long time ago and they forgot and there wasn't enough training. So it's always good for all of your medical documents to revisit them at least once a year with your medical director, with your staff, just to make sure that everyone still has a good understanding of what's supposed to be happening. And then,
So almost like as an HR compliance step, I mean, we do reviews. I mean, it'd be almost one of those things that you'd want to put in the employee's file or, as your standard protocol. Would you include any of what you just talked about in the actual job description? Let's stay on this injector example for a minute. We hire an RN injector. Would we define what areas, based on, would you define those in that job description as well, or just in this manual?
I for an RN injector, I wouldn't define like you're gonna do this kind of Botox, but not that kind of Botox in the job description. But I would say perform treatments in accordance with our policies and procedures. And then
Okay.
in the policies and procedures, describe what those are. Because also we don't want to change somebody's job description every time. So
Mhm.
I think it's better to just refer to this other document.
Yeah, because sometimes someone maybe worked for a previous plastic surgeon and they did tear troughs and they worked with, radius or whatever. And then they moved to a new office and they know how to do that. But maybe this new office owner and practitioner is uncomfortable, right? Doesn't want to take the risks of treating like you say, nose or tear troughs or something along those lines. So that's really where that is very much real world.
Yeah, definitely. And then on the other hand, in the non-clinical side, you definitely want to have an employee handbook and a manual of like the non-clinical rules that people are supposed to follow. For example, like, are people allowed to wear whatever they want? Are people allowed to vape at work? Are people allowed to come to work? If their first appointment is at 9 a.m., is it okay for them to come in at 9 a.m. or do you want them to come at 8:45? So things like that, everything like that should be spelled out to avoid misunderstandings and also really bad situations when employment ends. So that those
Mhm.
types of things being in place minimizes the amount of claims you'll get later where people are upset if, some things have happened.
Yes. So that employee handbook, basically, what is the dress code? What are the expectations of being arrival, departure, charting, even cell phones are one of the things that come up quite a bit, whether they can be in the room, or not, things like that. So it's good to think through all of those beforehand. And I know in one of the things I really loved about your service offering is you have these subscriptions by month, that come with a certain number of hours, and they also come with templates and kits to help businesses get set up for success. Is the handbook one of the, is an employee handbook or policies and procedures? Is that one of those templated type of things that you supply in these packages?
Yeah, so we have different templates for handbooks, for policies and procedures, and then we are able to customize it per state because since different states have different rules about like time off and who can do what and um, parental leave and things like that, sexual harassment training, like some states mandate that, some states don't. So we can customize those things to your state's rules because the one thing that's worse than having a no document is having a document that's not compliant with your state, because then your employee can say, well, I got this handbook, but it's incorrect.
Right, because it's the physician's malpractice that covers everybody, correct? And it's that insurance side of things. I mean, they've got to be certified and trained either by the laser company or by someone that's been trained by the laser company or the injectables, right? The certifications and keeping those current. And if there's CMEs that they need. But if you don't have things documented, it's going to go back to that owner.
Correct. Correct. Yeah, liability always flows up. So whoever is the highest licensed person in the practice and also whoever has the most assets will be the one that ends up getting into the most trouble or carrying the most.
What is your advice if an employee is in an office and they're asked to do something that they know they're not allowed to do, but the doctor's telling them to do that? I have experience of some awake surgical, minimally invasive things where nurses were asked to, push some different drugs through IVs that they said they weren't allowed to do, but yet the doctor said they can do whatever I tell them to do under my management, my scope. How does an employee handle something like that? And is that more of a state by state thing, or could you help a little bit on something like that? Because I get that question quite a bit.
Yeah, I would have to know a little bit more facts about that. I think it's hard, like on a podcast, to give advice on something like that. I think in general, I
Specific.
would say if you are being asked to do something outside of your scope, no matter the pressure, don't do it. Because at the end of the day, yes, your employer will be responsible, but you will also be responsible. So only do what you feel you're comfortable with. But a lot of things are so gray area in terms of scope. So sometimes like there may not be a very specific answer as to what can be delegated to you and what cannot be. So it becomes like more of a trust relationship with your employer. But I think it really depends. It really depends on the situation and what it is that you're being asked to do. But in general, if I'm representing the employee, I would say don't do anything that you're uncomfortable with. If I'm representing the employer, I would say don't ask people to do things outside of their scope. It's going to end up really bad for you because they are going to look into it and figure out it's outside of their scope, and then you're going to get in trouble too.
Some kind of a complaint, yeah. And that can happen, that definitely can happen. And it's just, things are in a pinch, things are busy. And if, a doctor will say, you're under my supervision, so do what I tell you to do. And it's a difficult position for an employee to be in.
For sure. Yeah. So the next big legal mistake that I see all the time is people signing equipment purchase or financing agreements without having an attorney take a look at them, and also not shopping around between different financing companies, or signing a personal guarantee without even realizing what you're signing. So that happens all the time. And a lot of times in the communications with your laser reps, they may tell you certain things that the machine does or doesn't, and it's not really correct. Like they may say, well, we recently had a situation where somebody said this laser can be used on tan skin, on any skin type. You can do this, but that's not actually factually incorrect. So sometimes things are told that are not exactly correct by the reps. Sometimes the contracts have terms in them that say you can't return this, or if you want to return this, there's a 20% restocking fee, or you're personally guaranteeing this thing, and if you want to prepay this loan, like you still have to pay the whole amount. There's no discount. So there are lots of kind of hidden terms in these contracts. So for all equipment purchases, like all major purchases, definitely get a lawyer to take a look at the contract before you sign it. A lot of things in there are negotiable. Even if a company tells you this contract is not negotiable, this is our form,
Mhm.
that doesn't usually mean anything.
I'd agree with that. And I was, I've learned over the years that there's a lot of negotiation of price, depending on what quarter you're in and how things are going. And you're right. Sometimes the reps are newer and they might be not even educated enough they think that a laser, or, I don't know that they're misrepresenting it. Sometimes they're newer and they don't even know, they think they know what is true versus clinical. So, and that spread between leasing agents, leasing amounts, the interest rates vary dramatically. And a lot of times the laser company is getting quite a benefit sometimes on that spread. So having a legal set of eyes look at it and make sure that you're not missing something, because there's a lot of areas that are tricky in that in the contracts and in the leases, and there's a lot of emotion going on and excitement when you're thinking about buying this new technology. So I see a lot of impulsivity where people think if they don't take that offer right then, it won't be as good later, which simply isn't the truth, but it definitely feels that way.
Yeah.
So to take the time to, to have someone review it and not to act on that, there's a lot of pressure to act from the sales side.
Yeah, and they're excellent salespeople. Like they're well trained in the sales cycle and emotional buying of people and all that stuff. So yeah, kudos to whoever trained them. At the same time, it's our duty, I think, to help our clients really understand that. And I think you have access to some better pricing, right, for your clients for some of these devices. So I think it's like it's worth going to a consultant to like you to ask, is this really a good price? Like, and does this laser do what it says it's going to do? And also, what's the feedback from other people that you know who've used this laser? And not the ones that the company puts you in touch with, but actual people like that,
Exactly. Yes. I talk about that. The two things I say is basically, yes, you need to reach out to someone that's not in your market that has that piece of equipment. And really the only question you need to ask is, would you buy that piece of equipment again? Or do you wish you had another one? Because that really tells you everything you need to know. But I do like to help them negotiate a good price and understand the other options that are parallel in the that might provide a similar result with a less expensive disposable, or maybe better training. There's so many options that go into these deals. You can wrap in a year's worth of marketing. You can wrap in sometimes a bunch of disposables. Many times it's at least 30% off the retail price, so if unfortunately, especially when you're just getting in the industry and you go to a trade show or you go to one of the weekends, typically those are definitely paying top dollar and not really getting the value they could. And, you can negotiate extra trainings and things like that, especially if it's a more advanced machine, like that really is subsurgical, like you're minimally invasive. One weekend is not enough. You need to negotiate second and third rounds of training. So yes, I think talking to either someone that's been in the business a long time, maybe another doctor or consultant, but the part of this business I love is there's always new technologies and new things that we can do. And so it's always interesting. But because of that, it's difficult sometimes to make an informed decision unless you talk to an expert that's really out there that knows, oh yeah, well, there's 17 different machines that do that. Let's talk about the pros and cons. And let's talk about, based on your needs. If you're really advanced and you've had two of those other machines and training isn't your thing, well, then let's save money and go with this other company, maybe that, they're not putting so much money into the post training. Or you're brand new and I want you to really be safe with someone that's going to go that extra mile to make sure that you have ongoing trainings so that you don't get yourself in trouble.
Definitely. Definitely.
That's really helpful. And if someone calls and they're signed up for one of your memberships in that, if they're negotiating or thinking about wanting to sign something, about how long of a turnaround would it take for one of your attorneys to review a deal and give them advice on average? What would be, if I was being approached by a laser salesman and I said, okay, I'm going to go ahead and run this by my attorney or my firm, and do I need 2 or 3 days? About what would be kind of a good guesstimate?
Yeah, 2 or 3 business days is typical. If someone tells us like we need it the same day, we could usually do it as well. But 2 or 3 business days I would say is typical. These contracts are actually usually quite short, but very small font. And they usually send it to you as a PDF. So they try to make it on purpose kind of harder to review. Um,
I like the DocuSigns on the phone.
yeah.
Those are
Yeah,
very helpful. That happens a lot. Well, and
those
you
are
and I both discussed that the part that so many people don't understand is when the minute you sign and accept delivery of that piece of equipment and they leave it there, you've bought it. You've driven the car off the lot.
hmm
Is now used, whether you open the crate or not. There's no take backs. There's no mulligans. I've had lots of people say, oh yeah, they delivered it, but I'm not really sure I want it. I'm going to really think about it and get back to them. It's like, okay, let me know how that goes. Because your experience, you tell me what's your experience with that?
Yes, that happens a lot, but yes, per the terms of these contracts, typically once you accept delivery, you bought the thing. It's yours and there are no returns. So, and even if you don't accept delivery, once you've signed the contract and it's in the process of being shipped to you, whatever that means, the companies try to make the argument that it's already in process of being delivered. The delivery process has begun, and then you're already obligated. So it's really important before signing the contract to have it reviewed by someone. Not once you have the
Yeah,
machine in your office and you're like, oh no, what did I just sign?
yeah. Don't
Because
don't sign anything. Don't sign it. And the other thing is, the promises that are made verbally, they have got to be in writing, right? If they're telling you we're going to give you this amount of disposables or this extra budget, again, it's really got to be in writing in the contract.
yeah, and if your rep is using like disappearing messages with you, like the disappearing voice messages and all that kind of stuff, you should feel like something is weird here. Why are they making the messages disappear? Right? Like if they could either say something in writing or not. So
Oh,
yeah, definitely definitely be wary of this new technique that I'm seeing.
okay, that makes sense. Yeah, and um, one of the things with leasing too is that deferred payment option, and you'll see that a lot. And again, that can have consequences. So I do think that there are 100 reasons why you would want to get it reviewed before you
Mhm.
sign anything. And if you're told, oh, you're the only one in the area that's going to have this, and I'll make sure that other people aren't having it, and you're going to be our luminary and our speaker. These kinds of things are said to close deals on a very regular basis. So it's important to get a second opinion.
Definitely. Yeah.
Well, that's a great one. Well, let's move on to your fifth. What's the fifth most common legal issue that you get calls about?
Something having to do with employees or clients, like some sort of lack of paperwork or some kind of dispute where either, let's say there's an upset client and they want a refund and what to do, and it's giving somebody a refund a sign of you admitting some kind of fault. And then also an upset employee where the employee relationship is ending and one person is claiming, discrimination and missed wages, and the other person is claiming breach of the non-compete. Those are the, I would say, the two most common employee and client issues that we see.
Well, and then by reaching out to you with that, you can supply some sort of departure agreement where both parties are agreeing. Let's say you decide to refund a surgery. There's ways to do that with a contract that will hold harmless, right? Or negotiate a treatment protocol to address the concern. And as long as these things are done and the refund is done, you want something signed, whether it's the employee that's possibly disgruntled or possibly a client that's not happy with their outcome. By going to you, you can give something fairly simple that, at least when we're done, we've got some closure and we've actually addressed the issue so that it doesn't raise its head again. Because you can refund someone and they can still go sue you and be angry about something that may be nothing on either side. So it's really, I would see that being a great service, if you are in either one of those situations, to reach out to your attorney for some assistance.
Yeah, definitely. And I think what happens in those situations is it's contentious and it's personal. And sometimes it's good to have like a neutral third party who's on you, but who's on your side. Like, so my job is to help my clients, right? And I take that very seriously. But I could tell you really how it is and what the real options are. And so a lot of times what happens is, let's say a client wants a $1,000 refund for their Voluma or whatever, and they're refusing to sign your agreement, your release that we already gave you that's part of our membership package. So what do? Do you give them the money back anyway, or do you hold firm in your position? And I would say you should give the money back anyway, because what happens is, if the person is still very, very much upset and they're not getting their $1,000 back, their next call will likely be to an attorney. And right away, that $1,000 problem will become a much bigger problem. So even if you're 100% right, and this person is being very difficult and is demanding this refund, it's easier to just make them a little bit happier most of the time and give them the money. And that's not usually an admission of guilt that's admissible in any kind of court case. So it's better to just give them the refund and move on than say, no, like, you're wrong, I'm right, you're not signing this, and I'm not giving you your money back. So that's my own advice based on seeing this so many times.
Right. I think that's really wise advice. And again, I think that that is something that more the newer practices that are trying to grow and cash flow is an issue and they're just getting started, it's harder for them to give a refund, than the experienced person that realizes this is much more of a headache. This $1,000 is not even close to worth what this could turn into. From experience, they realize that, and you're obviously sharing from that experience. And it's really important for people to know you're not admitting that you didn't do the service right or that you didn't create a result. You're simply avoiding something that could be a lot bigger later. And even I think it's even okay to say we really feel like you got the results, but for customer service reasons, we want you to be happy. So I'm going to extend this refund to
Mm-hmm.
you, not because we don't feel like the services were rendered, but if you're not happy, we want you to be happy, right?
Yeah, exactly. That's a really
And then
good.
you can avoid the bad reviews maybe as well.
Yeah, I think, look, there are laws that say you can't sign a contract with someone, and that includes something that says they're not going to give you a bad online review. So technically speaking, even if they signed a contract with you, if they're angry enough, they can leave you a bad review, and then you could have another different kind of legal case. So I think it just, as a general practice, it's better to try to pacify the person as much as you can within reason. So if
Yes.
they're like, okay, give me $1,000 refund for my procedure and also pay me $10,000, and I'm not signing anything, I think that, that's completely unreasonable and you should not do that. But if they're
Right.
just wanting a refund of their procedure and it's going to avoid 20 more hours of phone calls to your office and your whole staff talking about it, and this person leaving you 3 bad online reviews, I say it's worth it to just give them a refund.
Right. And 2020 hindsight, right? So you never know which client's going to do that. So as a policy and procedure, if you can't satisfy the client by additional services or additional, sometimes they don't have as a big of a result from a series of body contouring or something, and you do a couple more and they're still not happy, they still don't think they got a result. I agree with you, trying to refund them and having them sign something. If it goes that smoothly, that's probably your best way to go, and it'll hopefully avoid you just never know when the bad reviews are going to come. What are the statistics? If someone's happy, they might tell one person about their experience, and if they're unhappy, they tell 10 or 20 people about their experience. So we want to try to do everything we can to have them leaving feeling satisfied with the solution. So,
Yeah.
well, Sara, thank you so much for going over this. I know we're going to do another episode about employee issues because as a consultant, I get those all the time, but that was such a big topic that we were saving it for a second episode. But for today, I think this stuff was just so helpful. And the assumption that getting good legal advice is terribly expensive is simply not right. I love that you guys have memberships starting under 500, and you can go under 1,000 and still get a certain number of hours and templates and advice. And of course, if you have bigger things come up, that doesn't apply. but just to know that there are some subscription options out there to help when things come up on demand, and that you've got people across the country. I really highly recommend this as a consideration for those that are looking for an attorney, because it really doesn't have to be so expensive, and waiting until you've got a problem is not the way to go. Starting out with a relationship, and I love the idea of getting an audit just to see if you're in compliance. That is great advice.
Thank you. Yeah, prevention is way cheaper than correction, so it applies to Botox, it applies to legal services, and we like to see our clients be in a good place no matter what happens to them. And so that's our job. And yeah, it was really nice to be part of this podcast. Thank you so much for having me on.
Well, thank you. And I learned a lot of details as well. So thank you for sharing, and I'll be excited to talk to you again. And thanks for everybody watching. And as always, just remember, it's all about the implementation. So you've heard a lot of good advice. Now it's important to take action. And I hope that you all do. So thank you so much, Sara.
Thank you. Thanks, Kelly.
Bye-bye.
Bye.